A little bit about Funmi. She's the founder and principal partner of Funmi Roberts & Co., which is a leading internationally recognized law firm with chambers in Ibadan and Lagos, and collaborative relations with several international law firms. And she has an extensive background as a corporate commercial lawyer. So she comes to mediation with that sort of background. She graduated in a master's in law at the Nigerian Law School and has lectured in law at the University of Ibadan. She's a member of many different professional associations and organizations, including the Nigerian Bar Association, International Bar Association, and very many other organizations in the arbitration sphere that I'll mention a little later. And interesting for us in South Africa, has an involvement in the Association of Restructuring, Insolvency and Bankruptcy Professionals, as well as business recovery and insolvency practitioners. And this is an area I think that there's a great potential for mediation work in South Africa. And she works with me in CEDR on the CEDR faculty and is a CEDR mediator. And she's also involved in the Chartered Institute of Arbitrators in the UK. So she has a very international experience. She sits on a number of corporate boards and is a member of the governing body of the Oyo State Multi-Door Courthouse and the Lagos Court of Arbitration. Funmi comes to us with a fantastic background as a corporate lawyer and in the ADR sphere as well. And so welcome, Funmi. Let's begin. Lovely to see you.
Thank you.
So looking at that background and thinking about that background as I was preparing for our discussion, particularly your involvement in your background as a corporate lawyer and your involvement in arbitration, what made you add mediation to your skills and practice? What drew you to mediation out of that very busy world of litigation and law?
Thank you very much, Felicity, and I thank you so much for the invitation to share your global space with you this morning. And those of my colleagues from Nigeria who, despite the very short notice, joined this webinar, I'm very, very grateful to all of you. Before I commence, I want to acknowledge what is going on in my country right now and which is being played out on a global stage through several news channels. My country will be in the course of history. Maybe at a tipping point, I don't know. But I ever want to start by commiserating with the families of those who have lost loved ones and whose properties have been destroyed. And whilst also praying God to heal our land, even in the bid to achieve the national rebirth we all so much crave. Now, to your question, Felicity, how did I get into mediation? It's rather fortuitous, actually. In the early 1990s, I can't remember the specific year, the United States Aid Agency had a program called Women in the Political System. And they picked 20 women from all over Africa, and I happened to be one of them. We visited so many states, and in, I think it was Washington, we visited a particular court where I heard about the multi-door courthouse system for the first time. And by the time it was introduced to us, I became so enthralled and got back home, made inquiries at the United States Aid Agency office in Lagos, and heard about the group called Negotiation and Conflict Management Group, NCMG, which was founded by Mr. Kehinde Aino. Now, I always refer to Kehinde as the father of mediation in Nigeria, and it's a title well earned. So what did I do? I joined Negotiation and Conflict Management Group, and it was NCMG that brought CEDR to Nigeria to train some of us in mediation. And of course, everybody knows that CEDR is a globally recognized leader in the mediation space. So I not only passed that training, but I was also invited to join the training faculty of CEDR. And Felicity, incidentally, is the current head of training. So even though I'm an arbitrator and an adjudicator, I'm still very active in the mediation space. And believe me, Felicity, I just love being a mediator. And I've not looked back. I think it's the way to go, and I'll share more with you as this interview progresses. Thank you.
Felicity, you're muted.
Sorry. As Funmi said, the slogan of the time. Yes, so let me start by asking you about that background. I actually remember as well going to the Washington multi-door courthouse in 1991 and having that same experience, being so impressed by it. But you in Nigeria did something with that. And have really, that idea has taken off in Nigeria. We have yet to do that in South Africa. So tell me, how did ADR and mediation get off in Nigeria, get off the ground? What was it that was appealing to Kenny, to you, to the judiciary about mediation?
I must say that we didn't start the campaign with the judiciary. What we thought we needed to do was to appeal to our colleagues in the dispute resolution space, especially the core litigators. And I give kudos to Kenny. He infused so much passion in us. He drove us, and we were all fully committed to ensuring, because we don't even need anybody to tell us that we operate in an environment where mediation would help. And mediation, let me say, is not new to Africa. If you look at our background, if you go to the villages even today, you would find that mediation is still used to settle so many disputes. And what we thought was we need to bring this into the commercial space. And I'm sure with us today is Yinka Kolade. She was one of those who drove the train at that time. It was quite grueling, particularly for me, because I don't live in Lagos, but I'll find myself drive to Lagos for meetings, for seminars, delivering presentations everywhere, pretty much doing all the things that needed to be done. And initially, the gospel of mediation was a hard sell. We had to write articles, produce flyers, circulate at every opportunity. But soon we identified one of the stumbling blocks to the acceptance of mediation. And that was the fact that we needed to speak to our colleagues who are lawyers and try to convince them. As a matter of fact, in the course of it, it prompted me to write 2 articles. And one is mediation, a tool for developing commercial solutions to commercial disputes. And another was in pursuit of the client's interests, the role of counsel in the mediation process. And both were published by the Journal of the Chartered Institute of Arbitrators, Nigerian branch. But the narrative has now changed. And I think that it was the advent of the multi-door courthouse that changed the narrative. And I'll just give an example. There was a particular corporate commercial transaction lawyer that I had to negotiate dispute resolutions with in a particular contract. And he wasn't going to admit a multi-tier dispute resolution clause that gave the parties the opportunity to negotiate amongst themselves. If it failed, they went for mediation. But I insisted, and it almost broke my relationship with the client. But fortunately, I was able to persuade both the client and the counterparty and the counsel. But a few years down the line, a dispute arose predicated on that contract, and the dispute was settled by mediation. And incidentally, that senior lawyer, I met him at a virtual seminar a couple of weeks ago, and he was delivering his presentation. And he saw me and he said, "Mrs. Roberts, believe me, I'm now not only a mediation convert, I'm also a mediation apostle." So that goes to show how much mediation has been ingrained into our dispute resolution space. Now, let me speak a little bit about the multi-door courthouse system. I would say that it is really an advanced tool within the civil justice system to improve access to justice. And of course, we know that justice delayed is justice denied. But what did Kenny do? Because whatever we say, Kenny was the one who brought the idea of multi-door courthouse system into Nigeria. He approached the then Chief Judge of Lagos State and spoke about multi-door courthouse, and she was convinced. So they carved out a part of the High Court premises in Igboshiri and started the multi-door courthouse from there. Right now, sadly, one of the victims of the past incidences in my country is that that entire building has been burnt down. But that is where multi-door courthouse system actually took its roots in Nigeria. International trade and commerce cannot afford the length of time it takes to resolve trade disputes. Most legal systems encourage the preservation of families, and litigation does not seem to be the best forum for resolving family disputes, especially where children are involved, particularly also workplace disputes. So attention then turned from all the dispute resolution mechanisms we're used to, that is arbitration and litigation, and then other forms of ADR. And those are the offerings in the multi-door courthouse that we have in Nigeria. Section 6 of the Nigerian Constitution, for example, says that you cannot shut anybody down from going to court. But like Professor Frank Sanders said in his thesis on Comprehensive Justice Center, when you give parties the option of an array of dispute resolution mechanisms, you are also improving access to justice. And in Nigeria, the idea of having a multi-door courthouse is a partly funded government initiative, even though brought by somebody from the private sector. And what it does is that it integrates litigation with other dispute resolution mechanisms that are private, cheaper, and speedier, so that everything comes under one roof. And parties have the choice of going to any of the doors that are opened, virtual doors, or would I say mythical doors. And sometimes the courts themselves assign cases to the multi-door courthouse. And if they are not settled, then they go back to court. But once they are settled, then the settlement agreements are entered into as judgment of the courts, and they assume the same status as any other judgment rendered by a court. Right now, we have several multi-door courthouses in Lagos. In Nigeria, we have the Abuja multi-door courthouse, we have Enugu multi-door courthouse, and we also have the Oyo State multi-door courthouse, on whose governing board I sit.
Right, right. Thank you. That's very interesting. Now, I remember in Washington and actually also in Chicago going into the multi-door courthouse where it was a courthouse literally with doors down the passage and leading off the courtroom where there were mediators sitting. So it physically is a multi-door courthouse. Just describe for us how it works in Nigeria. Is it physically, you use the word virtual, so I'm not sure if it is physically, but how does it actually look? What's it like to work there as a mediator?
Well, it is not physical. I think the doors are practically mythical, but just, I think those words are used to give the perception that there's not just a sole door to dispute resolution. Door is a concept and not something that you'll see physically. If you go to the Lagos multi-door courthouse, for example, you'll just see one door into the entrance. But then when you get in, You have case managers who would explain to you the different options you have.
Mm.
Do you want to go for mediation? Do you want to go for early neutral evaluation? Do you want to go for arbitration? And they have a panel of neutrals. The panel of neutrals are in different segments. We have a panel of mediators, we have a panel of arbitrators, we have a panel of adjudicators. These are trained in the different dispute resolution mechanisms. Some courts are cross-board. For example, I am on the panel of mediators at the Lagos Multi-Door Courthouse. I'm also on the panel of adjudicators. I'm also on the panel of arbitrators. So they screen the people they admit to the panel of, to their different panels. So when disputants come, the case managers explain to them the different options they have. And it's for the parties, after listening to them, and of course, consulting with their counsel, they make a choice as to which of the different options they want to pursue.
Yes, yes. And sometimes people are concerned about the barriers there are to mediation, for example, the cost of mediation and paying for those mediators. So are the mediators paid or are they voluntary?
Well, they are paid, but compared to what you earn in adjudication or arbitration, not comparable at all. And for example, in Lagos Multi-Door Courthouse, the parties pay very little just to encourage them to come for the mediation, so that they don't give the excuse of the cost of the mediation adding to the cost of resolving the disputes. So the Lagos state government subsidizes to a very, very large extent what is paid out to the mediators. In Oyo State Multi-Door Courthouse, when we started, practically all the mediators rendered their services free, because it came in the middle of the disbursement of the budget, and it wasn't part of the budget at that time. Right now, we're trying to see how the fees of the mediators can be accommodated. But because the government, the judiciary sees this as a service to the country and not necessarily as a profit-making enterprise.
Yeah.
And that's why I always say that before you go in for mediation, you have to be very clear where you're going into mediation. You have to be certain of what you want to achieve. If it's all about making money, then perhaps mediation in a public sector organization like a multi-door courthouse is not the best for you.
Right, right. Now, if one party agrees to mediation and the other party resists it, is there any compulsion or any penalty at a later stage should the matter not be resolved and move on to a court?
Not in Nigeria, not in Nigeria. Or like in England, where you can be penalized on cost if the court is convinced that you did not mediate in good faith, but not in Nigeria. The courts would suggest you go to the multi-door courthouse, or you try to get a private sector mediator to resolve the dispute, but there's no compulsion about it. And if you recall, Felicity, one of the things we say is admirable about mediation is that it's voluntary. You don't have to sit in the room. Even if a court says you should go for it and reluctantly you go there, you don't have to sit down in the room and mediate. No.
And so this is intriguing. Do you have any sense of the extent to which, I mean, the numbers of cases that are mediated? You know, what impact is the multi-door court system having on the legal system?
Unfortunately, I don't have the data, but there is something, there's an event that the Lagos Multi-Door Courthouse does, and it's called the Lagos Settlement Week. And the way it's done is that there's an audit of all the cases in court, and the judges recommend some of them for mediation. And you have those on the panel of mediators of the Lagos Multi-Door Courthouse register their interest in participating in the Lagos Settlement Week. So in that week, you can have up to 1,000 cases go on assigned to different mediators who come in at different times to mediate. And at the end of the 1 week, the data is collected and the report published indicating how many cases were mediated that week, how many
Funmi.
and even for the instances that don't settle during the settlement week, a couple of months down the line, the officials of the Lagos Multi-Door Courthouse get a phone call to say that they've settled and they would like to distill the settlement in the form of an agreement.
Right, right.
But I know for a fact that last year they had almost about 55% or to 60% of the cases settled during the Lagos Settlement Week.
Right, and I recall that, and many of my colleagues on this meeting will recall that we did that IMSA, the Independent Mediation Service of South Africa, in about 1989, 1990, 91, when the Labour Court had, or I think it was called the Industrial Court at that time, had massive backlog, and that worked very well. So it's not something we've tried since. So I must say it's an excellent idea for us to contemplate.
I think you should try it, and I don't know whether there's a multi-door courthouse in South Africa, but I think your organization should give it a try. If you have enough mediators and you can collaborate with the judiciary to have a settlement which doesn't even have to be court-connected cases. Disputes can be brought in from outside the courts to your organization, and you have 1 whole week of trying to resolve this using professional mediators.
Yes, yes, yeah. And just a last question on the multi-door courthouse. Can you describe the attitude of the judges to mediation? You know, generally the judges and the clerks, you know, how have they been trained? Are they, you know, do they understand it well? Do they promote it? You know, what generally is their approach?
I would say that when we started, it didn't occur to us that we needed to carry the judges along. But when the Lagos Multi-Door Courthouse opened and judges were being encouraged to send cases to the Multi-Door Courthouse, many of them didn't understand why. And so CEDR, and I don't know whether you were part of any of the faculty members who came, entered into an agreement with NCMG and rolled out a couple of trainings for the members of the judiciary in Lagos State. And quite a number of judges attended some of these trainings from all over the country. And right now, I doubt very much whether there's any judge who has not heard of mediation. And you'll find that in their courts, without being approached or it being the Lagos Settlement Week, you find judges recommending mediation to the parties. Just before I traveled in June, I got a call from a judge who said that she had a particular case before her, and she raised it with the parties in the open courts that would they like to try mediation. And she described the Oyo State Multi-Door Courthouse to them. They turned down the invitation to go there, saying that they would not like to go to a public institution like the Oyo State Multi-Door Courthouse, but that if she could recommend a mediator in private practice to them. And I was recommended to them. I had to travel out of the country. I did the mediation online and the case settled, and the case had been in court for 7 years.
Yeah.
So for me, the attitude of the courts have changed significantly from what it was about 15 years ago. Yeah. And you'll find that apart from the high courts, we have the Court of Appeal annexed multi-door courthouse, we have in the Federal High Court, we have in the in magistrate courts in some jurisdictions as well. Not all of them are called multi-door courthouses, but at least they have systems in place that are akin to multi-door courthouses.
Yeah, right. Well, let's just turn to the individual mediator, because you've mentioned the appointment of a private mediator as another route. And we've got a question from one of our participants is, what do you suggest as next practical steps for individual mediators and mediators collectively like us to encourage mediation? So individually and collectively, how could we go about encouraging mediation, particularly to make it a viable professional option?
Now, one thing I've told several people is that you have to be sure that mediation aligns with your core values. If you're about helping people, being a peacemaker within an adversarial dispute resolution space, and still earn enough to support yourself and your lifestyle, then that is what you want. I am lucky in the sense that I was one of those who championed the cause of mediation in Nigeria more than 20 years ago. But even when I started, my expenses outweighed my revenue or my income. And the narrative for me only changed less than 5 years ago. The field has changed. There are many more entrants, and the trainings used to be very, very expensive with no job guarantees. If you train with CEDR, just like every other training institution, is not going to guarantee you jobs. But then in Nigeria, I think that the opportunities to become immediately engaged is greater if you live and practice in a state with a multi-door courthouse. And Felicity, that is why I say that you can't but have a multi-door courthouse system in South Africa. And right now, we don't bring in the entire CEDR faculty to train in Nigeria. We now have many training institutions. You attend these trainings, and it is important for you to be trained by a recognized training institute. Mm. And once there is a multi-door courthouse, you can join their panel of neutrals. Like I say, the remuneration is not as high because it is heavily subsidized by government, but you can actually stay the course. You have to be prepared to make significant time and financial investment. And it is also important that the fact that I keep saying this and you wonder why, the fact that you are trained as a mediator does not necessarily mean that you should practice as a mediator. There are other options for you. You can administer a mediation organization, for example. You can establish one and administer it. You can be a training, you can train mediators. You can be in the case management space. You can be a mediation advocate. And what do I mean by a mediation advocate? I know some of my lawyers, my colleagues in Nigeria, who went for the training, not necessarily because they want to practice as mediators, but because they know they've seen the value add of mediation, and they know that if they are trained and they understand mediation more, it will be easy for them to advise their clients about mediation and also support their clients during the process, thereby adding value to what their clients want.
Yeah. Okay. Yeah, that's really very valuable to hear, because I think I've always had the feeling that there's so much we need to do to support mediators moving into the field, and so good training is an opportunity to get involved. Good panels, CPD opportunities, all of that is ways in which you can expose yourself, continue to expose yourself to mediation after having been trained, and also enhance your experience. Funmi, if I can just ask you about the professionalization of mediation in Nigeria, because we're going to talk about that in relation to South Africa later. What qualifications do you have to A, join the multi-door courthouse, or B, be a credible private mediator?
To join the multi-door courthouse, you just have to be a trained mediator, certified trained mediator.
And how many hours training?
Well, in Nigeria, we're not big on CPDs, and I think just your certificates is enough. And what has happened now is that most of the multi-door courthouses also have their own faculty that does the training. So as soon as you do their 5-day training and you pass, you can immediately get on to their panel of mediators. They won't start by giving you cases. You'll probably need to shadow a few, of course, when shadowing with the consent of the parties before cases are assigned to you.
Yeah.
Like I said, we're not big on CPDs in Nigeria, but there's no special qualification. You don't have to be a law graduate. You don't have to be a graduate at all, because I know so many people who are mediators today and who are doing fantastically well and who are not university or even polytechnic graduates, but who have acquired the skills, because that's why when you go for the training, it's called mediation skills training. And it is not everybody who goes for the training that passes the training. So you have to ensure that you go for those trainings and then apply to the multi-door courthouses around you.
Yeah, yeah. Okay, if I can turn now to a slightly different question, and that is just about what Fola, one of our participants, has referred to as the misconceived notion of the non-bindingness of a mediation settlement agreement. So tell me, in Nigeria, would people generally regard a mediated settlement agreement as a binding agreement? You did say earlier that if it's in the multi-door courthouse context, it would become an order of court. But generally, are people clear that mediation agreements have the same status as an arbitration finding and as a contract?
I have no doubt about that. That's the general notion in Nigeria. Perhaps not at the beginning, but that perception has changed significantly. And one key point I need to make about the multi-door courthouse is that it is not only the cases that are administered by the multi-door courthouse that can be signed by the ADR judges. Now, what do I mean by ADR judges? Assigned to the multi-door courthouses, about 2 or 3 judges called ADR judges who sign the agreement, settlement agreement reached by the parties, and then it is registered in the court system and becomes a judgment of the court. For a fee, if, for example, you go to the Citizens Mediation Center, which is also another mediation center in Nigeria, and the case settles there. The Citizens Mediation Center is not a court-annexed mediation center, but you've settled and you've signed the agreement. You can take that agreement to the multi-door courthouse in your locality, and you go through a 2-week process. You pay a certain amount of money, and that agreement is signed by the ADR judge. And what happens is the ADR judge will call the parties on a particular day and ask them to confirm that that settlement is their settlement agreement. The judgment of the court. Is it also available to non-government administered mediation? Yes, from the private sector. But what I find, let me say, is that, at least in my own personal experience, the payer in a settlement agreement has not suffered a payer's remorse such that the agreement is cancelled. Because what I always ensured I did is to put in a clause in the settlement agreement that in the event that the parties are in dispute about the settlement agreement, they take it back to the mediation. And so far, when I follow up with the parties, they are quite happy with what they've signed on to. And I can't recall having heard of a situation where it has become the judgment of the court and a party had to take enforcement proceedings to ensure that the paying party adheres to it. I've not heard of that at all.
I think that's our experience too. Those of us who've been mediating for a long time, that I can't recall a single case where where parties have come back to me and said, someone's not complying with the agreement, what should I do next? Or because it's a negotiated agreement and people are, if they sign up to it, they're happy with it. There is a question from Mtumkulu about does mediation somehow dilute people's right to justice? But you very usefully refer to Section 34 of our Constitution in this regard. And Funmi, I think you said earlier that, and you referred to Sanders on this in his early days in the development of ADR through the Harvard Law School, that really mediation and the other ADR mechanisms provide a wider access to justice and in no way stand in the way of the party going to court if that is where they want their justice served.
I said, Felicity, it's a voluntary process.
Mm.
And you don't have to do it. What has happened is that sanctity of contract is key. If you've signed on to, before 1985, I think that was the year the wire cable and wireless case was decided in England.
Mm.
If you went to court to enforce a mediation agreement, the court will not enforce it because they'll tell you that, it's not certain enough. But when the provisions of the contract are such that it is very, very clear, one, that the parties have chosen to mediate, two, they even named the mediator or the mediation institution in the agreement, the court will enforce it. Mm. It is something you entered into voluntarily. No, I mean, for every well-trained mediator, during your opening statements, that is one of the things you tell the parties. If you are uncomfortable with the process at any time, let me know. If you don't want to continue, you have the option to leave. And once you leave, you can easily go back to court. Mm. So I would not agree that it stunts the access to justice. For me, it in fact improves access to justice. Because like I said, when we talk about natural justice, when you talk about fair hearing, you're also talking about the fact that if you delay justice, it may be justice denied.
Yeah. Thank you. That's very helpful. Well, you have extensive experience as a mediator, and I asked you when we were preparing for today to cite or describe a case where you found the mediation particularly satisfying, and to tell us what was satisfying about it, but also what the challenges were, and maybe how you dealt with those challenges. So give us an example.
This was a mediation we did early on, and it's about different claims of wrongful dismissal, denial of pensionable entitlements, or short payment of entitlements made by the former workers of a government-owned agency. Now, some of these disputes were already in court, subject of litigation in court. Now, then the external solicitor of the government agency, one of our most senior and respected lawyers in Nigeria, then suggested to that agency that, why don't we mediate this? Because they had over 1,000 cases in court. And some were even still preparing to join those cases that are already filed in court. So the agency agreed, and a panel of mediators panel of 3 was set up, and a newspaper advertisement was put out asking claimants to bring their grievances to the panel. Now, for ease of administration, we had to separate the different categories of dispute, and those whose appointments were terminated due to the 1995 industrial action they participated in, those who were compulsorily retired for various reasons, and those whose pensions were underpaid or were not paid at all. Or those, I mean, we had about 6 or 7 categories. And what we then did was to invite them at different times to appear over a 9-month period. I think we had about 25 to 30 full-day mediation sessions held over a period of 9 months. And to deal with the issue of authority to settle, we had to compel the managing director of the agency to come in from the Federal Capital Territory to participate in some of the mediation sessions. At a stage, it was the executive director, administration and management services, and also the company secretary. And the outcome of that process was that about almost 900 of those cases were successfully mediated. Almost 100 of them were suspended because the claimants wanted to take their chances in court. And we said they could come back if they wanted to, but they never came back. And only 2 failed. Now, mediation settlement agreements were signed and made the basis of consent judgment for those cases that were in court. For those that were not in court, we advised them to initiate the court process and then inform the courts that they've settled. And that was what they did. And post-mediation monitoring showed that the government agency complied with the terms of settlements reached. Now, you cannot have been part of such a process and not have this high sense of achievement and gratification. And that for me just validated the point that mediation works.
Yeah.
As long as the parties are willing to settle, mediation works. I have absolutely no doubt about that.
So one of the challenges there was authority.
Oh, yes.
Yeah.
But you know, because the senior advocate of Nigeria had done a good job of preparing the leadership of the government agency, it wasn't difficult to get them to come and join us in Lagos for the mediation sessions at all. But what we then did was we just made them participate in those with critical issues that we needed their input. But for most of them, they didn't need to be around at all.
Right. So that sounds like a mammoth task over many months.
It was.
Well done.
But the mediators and all the administrative expenses were picked up by government.
Right. Okay, thank you. There are 2 questions in the chat that tangentially relate to what you're saying, and that is, for a new mediator in the field, how would they go about setting themselves up this is not either Nigeria or South Africa or both? How would they get themselves set up so that they would be available for a dispute, maybe not of that magnitude to begin with, but be available and become known in the field as being available?
Well, it's just like any other business you go into. You have to network. You have to put your face out there. People have to know you. I see some mediators at functions, at events, and I look at their card and I can't see the word mediator there. And I've had to address a couple of my mentees in that space and say, I'm looking at your card and all I'm seeing is legal practitioner or solicitor, barrister and solicitor of the Supreme Court of Nigeria. Where on your card is the fact that you are a mediator? And some of them will tell me that, oh, I just printed this card and I don't want to waste the money. I then said that, how would I know that you're a mediator? You have to join different organizations. And right now, there's so many of them. One of the ones that just came into the field now is the Attorney Mediators Association of Nigeria. It's new, but well populated with members. You can write articles. There's so many platforms nowadays where you can hone your skills. And in the last couple of 7 months, I've met so many new mediators that I ordinarily wouldn't have met. But for the fact that we are all on a global platform, online platform, and we form relationships that way. You just have to put yourself out there.
Yeah. Yeah.
And there's just no other substitute, because you can't sit in your office. Even if you put it there on the board that you're a mediator, people are going to ask about what job have you done before? What type of mediation have you done before?
Yeah.
And believe me, the dynamics of mediation has changed and to continue to change. There are more and more people entering into the fray, but I can assure you that there's enough job for everybody as long as you position yourself. And the world is now a global village. We used to use that appellation, the world is a global village, but it has assumed a more significant dimension since the pandemic, when we all had to move online.
Mm.
I'm being interviewed, Felicity, by you in South Africa, and I'm based in Lagos. And we have colleagues from all over join this conversation this morning. And what was the first thing you did? You made me meet Jenny. You made me meet another South Africa, people I would ordinarily not have known. And I had a few minutes to introduce myself to them and tell them what I'm doing. And they shared that with me as well. So in every challenge, there are opportunities, but those opportunities can only be seen by the discerning and by those who are purposed in their minds to look for those opportunities.
Mm. Thank you. And in fact, Funmi, you and I had some time yesterday to prepare for this call, and it was at about 11 or 12 o'clock. And you said to me, send me the details so that I can put it on my LinkedIn. And between about 1 o'clock yesterday and this morning, roughly the same time, 50 Nigerians joined our meeting. So LinkedIn as a platform is absolutely critical. And if you are blogging on LinkedIn or putting articles on LinkedIn, joining groups on LinkedIn, people see it. They certainly saw your post. So thank you very much.
So you can imagine, Felicity, if I were on Twitter, if I were on Instagram, and I posted the same message out, the impact it would have had.
Yeah.
We'd probably have about 200 people join us today. But without apologizing to anyone, the only one I can handle right now is LinkedIn. So, okay. I mean, the opportunities are just there. But if you are on Facebook, if you're on LinkedIn, and you are posting things that are not relevant to your profession, people are not going to take you seriously. Mm. My LinkedIn messages are about my being a mediator, my being an adjudicator, my being an arbitrator, and what the work I do within the corporate space by sitting on boards, delivering lectures, and so on. It is all about my professional life. Mm. What I do in my private life, I don't even post it anywhere. Mm. Mm. I'm not going to go and become a fashionista, or the fact that I have bought a new dress and post it on my LinkedIn page. And even what I'm saying is that even if I'm on Facebook, if I'm on Instagram, if I'm on other social media platforms, I am going to use those platforms to promote my work on a global stage, and which has assumed completely new dimensions than it was even less than a year ago.
Well, I've just put into the chat the Conflict Dynamics Twitter handle, as it's called, which is a lovely name of @ConflictDynamo. And we would love you all to follow us. We're not as active as we could be, but if there's anything coming up, a training, a meeting like this, we do promote it on Twitter and on LinkedIn. So we'd be very pleased to have you follow us, and we will certainly follow you back. Great. Funmi, in your work as a lawyer, because I know there are many people in the meeting today who are solicitors, advocates, and from the legal profession, how do you talk to your clients about using mediation? And do you have any anxiety about losing work because they might go to mediation and not use you to progress a case through litigation?
Felicity, when we were launching the COVID-19 ADR initiative, one of the things I said is that when we were called to the bar, when we admitted into the hallowed chambers of justice, we signed a social contract with our clients. And what is that contract? To do the best for our clients at all times. It should always be about our clients. I am not saying that we shouldn't give credence to our economic needs as well. But if you put your clients first, and you know that this is a dispute that is best resolved by mediation, we would have absolutely no hesitation to refer that matter to mediation. And one just came to the family recently. Two friends entered into a business transaction. It went awry, and it could easily go for litigation. And I said, no, let's send this to the Oyo State Multi-Job Courthouse and let it be administered under CEDR scheme, administered by the Oyo State Multi-Job Courthouse in Oyo State. I have absolutely no doubt in my mind that if the right mediator is appointed by the Multi-Job Courthouse, it was a case that could easily settle, and it will settle. And you know, by the time, if you look at the statistics, Felicity, I'm not sure about South Africa, but if you Google the statistics online, you would find that almost 55 to 60% of cases that are in court eventually settle. Whether they settle by mediation or they settle by other means, I won't go into that. But the fact is that most of these cases settle. Mm-hmm. And by the time parties, sometimes when we introduce mediation to the parties and they insist on going to litigation, and they're at the first hierarchy of the ladder for 4 years, and the case hasn't moved an inch, they are more amenable to mediation at that time. Because I always say this, not every case is ripe for mediation at the beginning of the dispute, when parties are still positional. But let them taste the public justice system. And then a party loses, and one party says, I'm going to the Court of Appeal. After spending about 11 years, there's a particular case I love to give the example of. It's the SPDC case versus NNPC. That case started before one of the young lawyers that I have great admiration for was born, Isaiah Buzimo. 2 years ago, Isaiah was handling that case at the Supreme Court of Nigeria. The same case, but his father started before he was born.
Wow.
Wow, but it is reality.
Yeah.
So by the time the parties, if that case, I am almost certain that if somebody had introduced the parties at that time to mediation, they probably would have agreed to mediation, but nobody did.
Yes.
And that is why we have to amplify the benefits of mediation, the advantages of mediation. We don't have a choice.
Yes.
That is the role the moment we were admitted to the bar and we took that oath, we have signed a social contract with our clients to do the best for them. And that should be what informs all the decisions we take in our businesses.
Yeah. And what better example of denied access to justice and how mediation could facilitate that. Our time is marching on, but I want to squeeze in one more question, and it's a question that arises from a point that Abimbola has made in the chat about insurance, or she is from the insurance world. And I wonder if you can comment on the use of mediation in business rescue and some of the insolvency crises that organizations are facing at the moment.
Let me talk about insurance. If ever there is an industry that should embrace mediation, it's the insurance industry. I have done, at least in the last 5 years, I've done about 3 arbitrations on insurance matters. And in one of them, I told the parties, I recommended mediation to them, because I do that at every opportunity, even when I'm in an arbitration. And one of the things I forgot to mention is the fact that lawyers don't know how to make money from mediation. They see mediation as taking briefs away from them. And I tell them that hardly anybody will go to the formal mediation sector and not require a lawyer to write out the briefs that will be submitted to the mediator and support you during the mediation session. So you still have a role to play in that space. But in the insurance industry, mediation has a huge role to play. And that role has been amplified by the COVID-19 pandemic and the insurance claims that would come in.
Yeah.
I'm glad that it's coming from somebody who is very high up in the industry in Nigeria. And I think Bimbola is the vice president of the Women in Insurance in Nigeria. Bimbola, we can have a conversation about this. Mediation can work significantly well in the insurance industry because the party coming up to make insurance claim has already suffered a loss. Why do you want him to go through that again? By claiming a right that he had paid for over the years. Mediation can help in those cases, and it's significantly many more. Now, let me go back to the question you had asked about business restructuring, insolvency. And I'm a member of BRIPAN. And when I took the decision to go into that area of practice a couple of years ago, many people tried to dissuade me and said that it is a dangerous job. And that's why you'll see many receiver managers go around with security men. But having been in this sector for almost 12 years now, I don't move around that space with security men because I don't need to. The one thing that I say about mediation and learning how to be a good mediator is the fact that it changes you, it changes your life and how you perceive disputes. It changes how you deal with people, whether your professional colleagues, your friends, and your family. Now, when you are a receiver manager under a restructuring or insolvency or bankruptcy, you are practically taking over businesses of people who have expended time and money to build those businesses, but who unfortunately ran into difficulties. And what you are then saying is that because you owe me money, I'm going to appoint a receiver manager to take over your business. As the receiver manager, it is important for you to build a relationship with those people, because one of the things you're going to be doing, and without going into any apologies, is that you go in with the police, the directors are no longer entitled to participate in the decision-making process for that business. You are now the manager. Now they're going to fight you. They're going to go to court. They're going to try and take their businesses back from you. But I always say this, it's all a question of attitude and the approach you take to your work. When I started and I engaged with some of my colleagues that I
we might have lost Funmi. Just while we're waiting for her to come back on, she was, Funmi, there we are, you back.
Oh dear, I was talking and I didn't even realize that I'd frozen.
No, you're here, you can carry on.
Yes, now what I'm saying is that it is about the way you approach your work as a receiver manager. about the strategy that I approach, that I put into play. I'm not going to go there and be bullish about it because I understand, I empathize with you. And those are the things that we are taught as mediators. Whilst you are being firm in taking charge of that business, you need to be clear and focused about your goals. And for me, it's about business rescue and sustainability. I don't want to take your business away from you. But if you're not running it in a way that enables you to meet your financial obligations, then you need help. You need to be empathetic, you need to be patient, and you need to listen. You need to demonstrate a deep understanding of the erstwhile directors. You win them over to work with you collaboratively and turn a toxic situation into a positive one. You develop options with them whilst remaining firmly in charge and being firm when required. All these are the things that we're taught as mediators. And believe me, I have very good relationship with some of the business owners. I've entered into their business as receiver manager, and I still don't go around with security men. So for me, what I'm saying in essence is that I can't think of any space where mediation cannot work. If you're talking about energy, the development of energy now, I think CEDR is working with the United Nations to develop mediation skills in energy space, even in the green space. Even when people talk about green energy and so on, there will be disputes there. And what is the best way to resolve those disputes? It's not by going to courts or to ask who is right and who is wrong. And there is hardly any sphere of my life. Sometimes I forget myself and go back to where I was before I became a mediator, but I try as much as possible to allow my decisions in that space be guided by the skills I've learned as a mediator.
Well, Funmi, that's a wonderful place to draw to a close. Because not
sorry, Felicity,
yeah.
Can I just make a point? And I'm making this point particularly for those who are worried about whether the jobs are there in mediation. Believe me, 3 phenomena will impact significantly on mediation in the next decade. Number 1 is the effect of the Singapore Convention. It is going to make mediation more attractive for resolution of international commercial disputes, because it's going to have the same effect that the New York Convention had on arbitration. Number 2 is the effect of the COVID-19 pandemic. With the amplification of online and virtual dispute resolution, your mediation practice area does not have to be localized within South Africa. If you form good enough relationship, you can be in South Africa, you can be in Nigeria and handle the mediation in Canada. Then, for us Africans, the entering into force of the African Free Trade Agreement, which has mediation as the bedrock of its dispute resolution regime, there is a lot of work there. So if you do decide to practice as a mediator, I urge you to stay the course, whilst of course remembering that there are no guarantees. Thank you very much, Felicity, for giving me the opportunity to make that point.
Well, thank you. You've said it much better than I could have said it, how mediation really has become part of your professional life and very much broader, and how training as a mediator gives you the opportunity to influence not just in your professional work, or in your dispute resolution work, but in a wide range of other sectors and areas. And so really, I invite anybody who would like to talk to us about an idea and how you might develop it. We'd be very, very keen to do that. We're doing some interesting work in schools and have various plans on the cards. Funmi, thank you so much for your time, for your preparation, your candor, your openness, and your very helpful ideas on how we both in South Africa and I think for colleagues in Nigeria can move forward with mediation. So
thank you very much, Felicity, for having me. It's been a pleasure to be in the same space with you as usual, Felicity. Thank you so much.
And I know if we could all clap, then we would all clap. So thank you very, very much.
You're welcome.